Now, what they will argue is that they don't use this for nefarious purposes against American citizens. In some ways, that's true. But the real problem is that they're using these capabilities to make us vulnerable to them, and then saying, while I have a gun pointed at your head, I'm not going to pull the trigger. Trust me.
Edward Snowden, whose leaking of information about our intelligence gathering continues to be a point of contention in Washington and elsewhere. And obviously, as Congress tries to decide whether to renew, amend, or rescind the Patriot Act, this kind of discussion continues very much in the news. Let's continue that discussion by calling on Ron Goldfarb. He is the editor of the book entitled After Snowden: Privacy, Secrecy, and Security in the Information Age, and he Skypes in tonight from Arlington, Virginia. Ron, it is good to have you with us.
Thank you. Happy to be with you.
I'm doing fine. Point of clarification: you are in Alexandria rather than in Arlington. My apologies for that, sir. But let me ask you about the debate that rages across the river on Capitol Hill about the Patriot Act. Do you believe the essence of the debate is captured in the book that you edited?
I do. Certainly, the issues that this debate is about are covered by people who know a lot about it. One of the interesting things about what's going on in Congress now is, instead of the typical polarization of the right versus the left, you have an interesting merger of different political ideologies. So you can't say this is a Republican issue or a Democratic issue. It's very mixed. You have, on one hand, you have a very small group, which is the Mitch McConnell point of view, which is we need to extend the act. Then we have Rand Paul, who, as you know, did a mini filibuster the other day. He doesn't want this act or the Reform Act. He just wants it to go away under the sunset provision, which will end the old Patriot Act on June 1st. Where we're likely to end up is where Congress doesn't end up most of the time, which is an interesting bipartisan compromise bill called the Freedom Act, which will correct some but not all of what was objected to in the former Patriot Act. So it's very interesting. We have tripart government really working. You have an executive program, which the courts have a couple of weeks ago said were illegal, and you have now Congress coming in to decide what, if anything, we should do. And it looks like we're heading towards a reasonable compromise.
So when you talk about that compromise, the phrase that comes to mind is former President Clinton on another issue, I believe it was affirmative action, when he said, "Mend it, don't end it." And you think that's what the USA Freedom Act will allow to have happen? You expect that to be the ultimate outcome?
Well, I do. And one of the reasons why that's wise is this is not an either-or issue. Rational people all agree we want national security. Who wouldn't? And most people agree that they want their privacy protected. Who disagrees with that? So we're not talking about either or. We're talking about, I think rational people, reasonable people are talking about, how do we protect the national security, which of course we all want, and at the same time avoid excessive provisions, procedures, programs that have taken us too far and aren't really netting us any good in the process.
Ron, the former director of Central Intelligence, James Woolsey, appeared on this program last night and made a cogent, credible defense of renewing the Patriot Act based on case law involving the Supreme Court and letters. He was making the case that technological expansion into email is really what the court decided on first-class mail. What do you think of that argument as advanced by Jim Woolsey?
Well, I didn't hear it in full, and so I don't want to criticize something I didn't hear. But we already have the most prestigious appellate court in the federal system 2 weeks ago, the Second Circuit in New York, ruled that under the Act, the acts of Section 215, which is one of the controversial areas, the collection of telephonic metadata was illegal under the Act itself. They never even got to the constitutional question, which a lot of people argue under the Fourth Amendment would throw out this provision if not the Act. So I don't understand what legal precedent he's talking about. The one I'm talking about is 2 weeks old and from a very high. It's one step below the U.S. Supreme Court.
Well, apart from what jurists may write in opinions, let's talk about something you wrote, an op-ed piece for Time, where you argue that without the Snowden leak, our system could have failed. Why do you think this is so? We have about a minute left, Ron.
Yeah, well, it wasn't working because the Congress, in its oversight of this executive program, only knew what the executives in NSA were telling them. And the courts, which are supposed to be deciding issues like this independently, were abdicating and not issuing opinions when cases came before them. If the claim was made by the government that something was a national security matter, they just backed off. So I don't think courts should really be deciding these issues. I think Congress is the place. Congress speaks for us all. There are different points of view there. They speak for the people. And I think what's going on now in Congress is the right place for these issues to be decided. And I'm hopeful that before the act disappears on the 1st, a credible, balanced.
And we will keep an eye on that, Ron. We will see if that balance is achieved before June 1st, as you say. Ron Goldfarb, editor of the book After Snowden, Privacy, Secrecy, and Security in the Information Age. Sir, you have our thanks, and we're coming right back.